Welcome back everybody to the Law of Trusts. We're continuing in this video talking about the formalities for the creation of a trust, focusing on the formalities in the creation of testamentary trusts. We'll explore in this video what a testamentary trust is, before then moving on and talking about the ways in which a testamentary trust is actually created, the formalities for doing so, the requirements therein, and the legislation which provides for these requirements. So, like I said, in the previous lesson, what we did was talk about trusts which are created into vivos, which are created at the point at which somebody is still alive, or where they're a settler. This lesson is going to spend some time talking about the circumstances in which the trust in question, the type of the trust in question, is what we call a testamentary trust. We note that this is a type of trust that is created through the execution of a will, the last will and testament of the person who is creating the trust, who of course is dead at this point, who is therefore the testator. Hence why we get the name testamentary trusts. Now, fundamentally, the regulation of testamentary trusts is found in the Wills Act of 1837. And so the reason that we have, why this is quite useful for us is because it therefore means that we have some quite specific legislation that is precise and is particularly quite clear about the processes and the creations, and more importantly for our purposes, the formalities that are required for the creation of said trusts. What the Wills Act of 1837 does is regulate a number of different areas, not just the regulation of testamentary trusts and the formalities for the creation of a testamentary trust, but it also regulates areas relating to wills and the administration of estates. If you are somebody who is doing the SQE and you are studying wills and estates, you will be familiar with the 1837 Wills Act. In addition to those of you who may be studying the law of succession more broadly, which is just this sort of the process by which title is succeeded upon the death of an individual, which is of course an area of law that can be studied either through the SQE or even at university, depending on which university you go to. So if you are either studying the law of succession or you are studying the study of wills and administration of estates, you will be familiar with the Wills Act. Now, when it comes to the validity of a testamentary trust, this is outlined through Section 9 of the legislation. And Section 9 says the following. It says, "No will shall be valid unless it is in writing and signed by the testator, or by some other person in his presence and by his direction, and appears that the testator intended by his signature to give effect to the will." And Part C says that the signature is made or acknowledged by the testator in the presence of two or more witnesses present at the same time. And then D, each witness either attests and signs the will or acknowledges its signature in the presence of the testator, brackets, but not necessarily in the presence of any other witness. But no form of attestation shall be necessary. So, what Section 9 of the 1837 Wills Act, that is a typo, apologies. What the Wills Act actually does is it gives us the negative. So it says that a will cannot be valid unless the things that are cited here are present. So parts A, B, C, D in the various different contexts have to all be present in order for the Wills Act to be, in order for the will to be valid under this particular provision. So, what does this mean? It means we can actually derive the formalities for a testamentary trust on the basis of these particular pieces of legislation. So, we can therefore, as a result, like I said, of Section 9, derive these formalities. And the formalities are simply the requirements that are necessary for the creation of a will. So the formalities will be such that an instrument can only be valid if it is made in writing, if it is signed by the testator or someone acting on their behalf or under their direction, It is witnessed by 2 or more people who will attest to the will. And there is also an additional amendment made, in fact, that was valid up until the 31st of January 2024, which gave a slight amendment in relation to the COVID-19 pandemic. Because according to the COVID-19 pandemic, the idea of presence in relation to Section 9 of the legislation, i.e. the signature is acknowledged by the testator in the presence of 2 or more witnesses present at the time, it was originally formulated that this was an in-person presentation. But of course, because of the COVID-19 pandemic, there was this limitation on the amount of people who could actually congregate in one area at one point, which meant that for the purposes of the legislation, presence included video conference or other visual transmission, but again, only valid until the 31st of January 2024 this year, because therefore that meant that the idea of firstly, the pandemic was over and is considered to be over, at least at the time of recording, and so it basically allowed for social distanced video conference presence rather than having to be in person.